Good afternoon, Mr. Dunlop.
Good afternoon, my lord. I have a witness this afternoon. It's Mr. Foulis.
Good afternoon, Mr. Foulis.
Good afternoon.
Right, when you're ready, Mr. Dunlop.
Thank you. Good afternoon, Mr. Foulis. I wonder if you could provide the inquiry with your full name, please.
Yes, it's Jamie Monroe Foulis.
Thank you. And I believe you've provided a statement to the inquiry, is that correct?
Yes, that's correct.
And just for the benefit of the recording, the statement number is PSR 0110. Can I ask, what are you employed as, Mr. Foulis?
I am a partner in the firm of Balfour and Manson, practising as a solicitor, principally in the field of family law.
Okay. And when did you qualify as a solicitor?
Began my traineeship in 2011, qualified in 2013.
And you said that you specialised in family law. Is that what you've been doing throughout your career, or is that something you've recently?
No, throughout my career.
Okay. And are you accredited by the Law Society of Scotland in any particular areas of law?
Yes, I'm accredited in the fields of family law and regulation of professional conduct.
Thank you. Now, can you tell me, you're here today to speak about the Family Law Association of Scotland. Can you tell me, what is that?
The Family Law Association is a members' organisation set up principally for people practising in this field in Scotland. It's supposed to do a range of things. It's supposed to provide training for members. It's supposed to engage with and promote law reform in the field of family law. It's supposed to promote family law as a field in its own right and encourage an approach to the practice of family law that avoids, I suppose, what I'd describe as unnecessary conflict being created. And it's also intended to be a point of contact or a reference point for the public in relation to the field of family law as well.
Thank you. I wonder if I could go over just a few of the points that you've dealt with there. And in terms of its aims and objectives, I think you deal with that in paragraph 6 of your statement. There's a number of bullet points, and you say it's to promote family law and so forth, and to provide a point of reference for the public. And you mentioned the public. I suppose just dealing firstly with its objectives, how does it go about, I mean, these are objectives, how does it go about in practice achieving these objectives?
Well, so taking them in turn, I suppose, promoting family law as a branch of law in its own right, we advocate for it as a specialism. We engage with law reform through taking up the opportunity to engage with and respond to government and Scottish Law Commission consultations in that area. We provide education and training through our annual conference, which takes place in November, as well as smaller scale seminars and CPD events, which usually take place a couple of times a year. When it comes to a point of reference for the public, primarily that is done through the website of the Family Law Association, where members of the public can search for a family lawyer in their local area, where they can find general information about the field of family law, and members of the public can contact the organisation about matters of public interest in relation to the field, albeit we don't as an association provide advice to members of the public.
Okay. So it's a reference tool, is it, for the public, rather than there's a direct communication between the association and the public, is that?
Yeah, that's fair.
Okay. And sorry, I should have asked you, you're here speaking on behalf of the Family Law Association. Do you have a particular role within the FLA?
I'm a committee member and I'm currently the treasurer of the Family Law Association.
And how many members does FLA have?
We currently have around 300 members, I think.
And are they, and I think you said that they're all practising in the area of family law, are they all are they all solicitors, or are there some advocates, are there some paralegals? Is it?
The vast majority are practising family law solicitors in Scotland. There are some trainees, some paralegals, some legal academics, some members of other professions who interact with the field, financial advisors and the like. I think one attorney, and that's a fair summation of the membership, I would say.
Thank you. Now, I want to look at the impact of the pandemic on various groups of people, but firstly, I want to look at the impact on the association itself and its members in the context of the association, not in the we'll look at the members in the context of operating their firms later. And you deal with that at paragraphs 8 to 12 of your statement. And I suppose one of the first things you said was that you offer training. Can you tell me, how was the training impacted as a result of the pandemic?
So I suppose the centrepiece of our CPD offering is our AGM, which traditionally has been conducted in person. That's a 2-day training event that would usually take place in November. That didn't run in the 2020. It ran online only in 2021 and then resumed taking place in person in 2022. I think our view as an association was and continues to be that particularly for an event of that scale, we usually have an attendance for the AGM in the region of about 100 to 150 delegates. There is a real value in that being in person and it providing an opportunity for interaction with your peers in this area. So although when it was run online we felt that was a success, I think in an online environment it's difficult to recreate that, I suppose to an extent, social and interactive aspect of the conference, which we've always considered to be very important.
Well, I think you said at the outset that one of the aims or objectives was to resolve disputes. I mean, maybe I don't want to put words in your mouth, but to resolve disputes without kind of conflict. I think, does the Family Law Association, do these training events and AGM, do they offer an opportunity for family law solicitors essentially to get to know each other so that they could contact each other to avoid, I suppose, the court?
Yes, absolutely. I think it offers an opportunity to discuss active cases in a slightly less formal, less organised fashion, I suppose. But in addition to that, I think having an opportunity to build a relationship with other practitioners in that area, independent of any cases that you are dealing with them in connection with, I think is invaluable when you come to a point where you're trying to resolve particularly difficult and acrimonious disputes. I think the ability to have a discussion with somebody with whom you already have a reasonable working relationship that can be built at events like that, I think I have always found to be extremely helpful.
In terms of the impact on the association, we've obviously discussed just there the training and the AGM. Were there, and I'm focusing on the association rather than the members and their practices at the moment, were there any other particular impacts that the association experienced as a result of the pandemic?
Not in a way that I would say was detrimental. Previously, our committee meetings would be in person at a range of locations, generally around the Central Belt. Those moved to being online via Zoom or Microsoft Teams. But that did allow the business of the committee to continue to be conducted, and in fact the majority of committee meetings since have continued to be online simply for reasons of convenience.
Okay. Moving on to the impact on the members, you, in their practice as family law solicitors within Scotland, at paragraphs 13 to 24 of your statement, you discuss the impact on members. And the first point you discuss is in relation to the financial impact, essentially, on legal aid practitioners. What you don't mention, and I wonder if this is worth noting, what was the financial health of legal aid practitioners practicing family law like immediately before the pandemic?
I think beforehand it would be fair to say that it was tight. Precarious is perhaps a reasonable description. The level of remuneration afforded by practising on legal aid in the field of family law is such that there are significant problems for individuals to obtain representation on a legal aid basis across vast parts of the country. And I think, at least initially, for that to be squeezed further for the reasons that I've mentioned in my statement, added to what was an existing problem.
And that was the point I was going to come on to. In terms of the pandemic, that added an additional pressure insofar as it took longer. As I understand, legal aid operates insofar as you don't get paid until the end of the case. Is that, if I understood you correctly?
Yes, in certain instances there is an ability to apply to the Legal Aid Board for a payment to account. But your ability to render your final account to the Legal Aid Board and to be paid for the work that you have undertaken as a whole only crystallises at the end of the case, where you either have a final order from the court or you have a final written agreement that's been executed by the parties.
And I think some of the points you make, excuse me, in your statement is that delays to cases meant that there was a delay to being, essentially, the solicitor being paid. But equally, if cases weren't calling in court, there was less opportunity for solicitors to essentially resolve the dispute kind of face-to-face. Is that, do I understand you correctly?
Yeah, that I think is based on the nature of the practice and the pressure of time that solicitors who operate busy legal aid practices experience. They are in court for the vast majority of the working day most days, and so their best opportunity to discuss cases with their peers will often be physically in the courtroom when they encounter their fellow professional. And if you are conducting business in court online, whether that be via video conference or telephone, it's a lot more difficult to stir up that conversation that you would have the ability to do if you were in person in court with the other practitioner.
And how did you, is that something you've experienced personally, or was that something that was being fed back to the association, or is that just something you know from, well, how do you know it?
Well, I'm aware of it anecdotally from other practitioners. I'm also aware of it, I suppose, from the other side of that dynamic, from trying to identify and arrange a time to speak with a fellow practitioner for whom the majority of their practice is on legal aid. So they are someone who operates the type of practice where they are in court frequently and regularly, and their availability out with court is fairly limited.
Would it be fair to say that would be an issue not just for legal aid practitioners, but family lawyers generally, that the ability to have a chat, for want of a better word, with their opponent in a dispute may be more likely to lead to a resolution than if it was just to trundle along the remote rail line, so to speak?
Yes, I think so. I think the same principle applies in relation to there being in court a greater opportunity for a spontaneous conversation as opposed to something that's had to be pre-arranged and organised.
You mentioned in your statement that the pandemic, in your opinion, had less of an impact on solicitors who largely had a chamber-based practice. And is that just simply because they weren't appearing in court?
Yes, I think so. I think it would depend on your level of IT provision and the arrangements that you were able to put in place to conduct your business once the country went into lockdown. But speaking from my own experience, it was still possible to speak with clients, obtain instructions, communicate with other solicitors, prepare agreements. Those aspects of practice could still be conducted. What changed was how you did it, and in relation to some cases, perhaps how well you felt you were able to do it.
And in terms of how you were doing it, it's a typical family solicitor prior to the pandemic, would they have been principally office-based?
Yes.
Okay. And following the lockdown, would they have principally been working then from home?
Yes.
Okay. So thinking of those differences, I mean, the first point, I suppose, is in your experience, from your perspective of being within the Family Law Association, did the members of the association largely have the IT equipment and skills, or were there gaps?
My experience and my understanding anecdotally was that if they didn't already, practitioners did acquire and develop it very quickly. Whether that was themselves or through IT and administrative support that they had within their own organisation. Generally speaking, what I saw from other practitioners within this field was that they were able to continue to servicing their caseload, communicate about cases. The times at which they did so may have changed because of domestic circumstances and the like, but I felt that as a professional body we managed to continue practicing and providing a service to the clients who instructed us relatively quickly.
I wonder if you can tell us whether there was a difference in the small legal aid high street kind of practitioner compared to the larger firms. Like, I don't know if Balfour Manson has a dedicated IT officer or person, but that wouldn't necessarily be the case in the high street, the legal aid high street. I wonder if you're aware of any difference in whether the smaller practitioners, perhaps with more senior, I suppose, solicitors who've been qualified for a longer period of time and may not have been brought up with IT, whether they struggled more than the younger ones in the larger firms.
I don't know specifically. I think what I would say is that my experience from acting on the other side of cases was that those practitioners were able to or found a way to continue to conduct business and represent their clients.
I suppose just dealing with they're working from home, they had previously been working in an office. In terms of family law clients, would they normally, prior to the pandemic, have come into the office to have face-to-face meetings?
Generally speaking, that was my experience, yes. The ability to offer an online meeting or more frequently a telephone call was still there, and for reasons of convenience you might do it. But my own experience was that unless there were logistical reasons why it didn't make sense, most meetings would be arranged to take place in person.
And I suppose comparing family law clients as opposed to conveyancing or commercial clients, and I'm sure it's stressful, everyone buying a house and so forth, but in terms of family law clients, do they tend, in your experience, to be more anxious or in a vulnerable state when they are meeting with their solicitor?
They can be. I don't think I would want to apply the same description to everyone. There are people who are, or at least appear to be able to deal with what can be extremely unsettling changes in their personal lives in a fashion that appears very stoic. There are others who make it apparent that to a large extent their world has fallen or is in the process of falling apart. And I suppose that there are two perspectives, I think, on what works best when it comes to a discussion with an individual in those circumstances. There's my perspective as somebody trying to give them advice, and there's their perspective. I think, from my perspective, there can be a lot of value in being able to sit down in person with someone and react and respond to their body language in what you're saying, but also in physically how you're holding yourself when you're speaking to them. Whether that be trying to provide reassurance or calm or whatever else. So I think the diminished ability which I think you have to do that over even a video meeting was a difficulty in how we practice. From the perspective of the clients, I think it varied. I think there are some who, if they were asked, would say they didn't mind, they didn't care whether a meeting was in person or over a video call or a telephone call. And once you were able to offer in-person meetings as an alternative, there weren't a huge volume of people who would choose to sit down in person. There were some, and so I'm reluctant to speak for what was best for the clients. I know what I felt was best and what I feel in certain situations is best.
For those that did want to meet in person, was there a particular characteristic that jumped out? Well, it's always this client involved in this particular case, or it's always this client. Is there? Can you kind of define, or was it not as easy to do?
I think it's difficult. I think individuals who were more elderly would find it more of a thought to be conducting what would feel like a very formal conversation over a computer screen. And often, even if you were speaking with them over that sort of medium, it would be facilitated by a friend or a child, which brings with it challenges in terms of how confidential that is. I think there were also instances where, although a couple had separated, they were still living in the same house for financial reasons or due to restrictions or due to childcare reasons or whatever else. And that would bring with it challenges when it came to trying to discuss, advise, obtain instructions on issues during the course of a case. So I suppose, broadly speaking, those would be the two categories of people who would prefer to take up the option of an in-person meeting if it was available.
And you said there that some of the clients, I think you said the elderly clients, the remote meeting may be facilitated by a friend or a child. And is that because they didn't either have the IT equipment or skills?
Yes.
Yeah. Okay. I want to ask you some questions now about the courts. And is your practice principally in the court session, sheriff court, or is that a mixture of both?
Mixture of both.
Okay. And we've heard evidence from the Scottish Court and Tribunal Service, but I just want to ask you some questions really about your experience or the experience of the members of the association, in particular in terms of, I suppose, sheriff court actions in particular. I'm interested in, was there an impact on child welfare hearings?
Yes, a significant impact.
Can you tell us in what respect?
Well, I suppose, firstly, during the initial period of lockdown, child welfare hearings didn't take place. Those resumed again relatively promptly after a matter of, I think, a couple of months. But when they did resume, the way in which they were conducted was significantly different from how they had been beforehand. They're now far, far closer to what we had before, but with a greater degree of flexibility. But initially, when child welfare hearings resumed, those would be conducted by telephone. Now, prior to the pandemic, a child welfare hearing was one which would take place in person. It was a hearing where there was a requirement that the parties, the parents, would be in attendance, unless the court excused them. And depending on who was presiding over the child welfare hearing and their preference, the parents could take quite an active role in the child welfare hearing. Generally speaking, the advice that I would give to a client going into a child welfare hearing would be, broadly speaking, when it comes to addressing the sheriff, don't speak unless you're spoken to. But there are some sheriffs and judges who find it very helpful to address the parties and get the information directly from them. There are others who prefer to avoid that. The telephone hearings, generally speaking, wouldn't involve parties. Solicitors were free to make arrangements for their clients to be able to hear. How you did that was a matter for you, and it was very difficult when what you were dealing with was a telephone call. Once you were able to do so, you could try to have the client into your office to hear with you, socially distanced. I think there were occasions when practitioners would try to play it over a Zoom call or the like, so the client could at least hear what was going on. But logistically, that was very difficult. And if you didn't do that, you were going from a situation where your client would have been, at the very least, a physical presence at a hearing, and often an active participant in it, to one who really had no role beyond finding out what the decision was after it was made. And the decisions at child welfare hearings can be very significant for a parent. They can be decisions about whether or not, on an interim basis, they are seeing their child at all. Or if they are, whether that is overnight or a couple of evenings a week at tea time. They can be decisions about where a child lives on an interim basis, whether that's with mum or dad. So these are decisions which, for the time being, can have a significant impact on the lives of children and their parents. And I think to go from a situation where the parents played an active role in that to one where they were often spectators at best was significant. Once hearings began taking place on WebEx via video conference, the parents would have the ability to be there. There was a logistical challenge then if they weren't physically in a room with you about how you obtained instructions and input from them as the hearing went on. And that was often done via text message or email. But that was a step in the right direction. And we now have something closer to a hybrid system where the default position is that a child welfare hearing will be in person, but if there is a particular reason why, courts will accommodate that being conducted via the WebEx video conferencing system. And I think that flexibility is helpful.
And just dealing with the sheriff court in particular, the sheriff courts, in your experience, were they all applying the restrictions in the same way? Consistently, I suppose, is a better way of putting it.
I think in terms of how hearings were conducted, that varied quite significantly, or certainly the rate of change from telephone to WebEx to in person varied quite significantly.
Can I deal with that, maybe just that point?
Yep.
I think you deal with that later in your statement. You mentioned that the Court of Session, I think you say, was dealing with proofs by WebEx, and issuing opinions by I think it's in paragraph 24, if we're jumping forward slightly, I'll come back. You say that the Court of Session was using WebEx very early on in the pandemic, and you say that judgments were being issued by July 2020. But then you go on to tell us that the Sheriff Courts essentially lagged behind, and that they were trialling WebEx in the second half of 2020, and certain Sheriff Courts it was into 2021. Do you know why there was a difference?
I don't know why. I think that the anecdotal understanding amongst practitioners was that it was partly to do with the systems in individual courts and the capacity of those systems. But I haven't seen a written explanation as to the reasons for that.
Where
I could actually tell you, but I better not.
well, I was going to, in terms of clients, would they choose to litigate if they had the option in a court where it was done by WebEx as opposed to by telephone?
Well, often you wouldn't have that luxury because of the jurisdictional rules. If you wanted to litigate in a particular sheriff court, in a sheriffdom, then you would need to satisfy the jurisdictional rules to get your case into a court in that sheriffdom. So, whilst it might be attractive, that was an option that wasn't available to a lot of people. You would have the ability to bring your case into the Court of Session as opposed to a sheriff court, but that was a decision which I think would have to be carefully considered, because litigating in the Court of Session brings with it additional cost.
Okay. Going back to the particular types of action, at paragraph 21 of your statement, you mention child protection proceedings you're involved in, and again, without naming any of the individuals, could you tell me about the particular example in paragraph 21 and what I suppose, what difficulties you experienced with the guidance that was being issued by the Scottish Government?
Well, that was a case where a sheriff in Inverness, if memory serves, had made an interim compulsory supervision order that made certain provision for contact. And the position of the local authority's social work department was that they were not able to safely implement that direction in relation to contact. And as a result of that, they had brought proceedings in the Court of Session seeking to have that direction set aside. The direction in relation to contact provided for contact either taking place in the open air or within the home of the children's parents. And I don't think it was so much the guidance that was in place at the time as what the local authorities' social workers felt that they were able to do safely that presented the issue. But the local authority in that case was sufficiently exercised by what had occurred that they felt it necessary to bring these proceedings into court. Now, ultimately, that application was refused and the decision stood. But I think that was, rather than an issue with the guidance, more a jarring between the expectations that arose from the guidance and what the local authority and its staff felt that they were able to safely do in the circumstances.
I'm not a family law practitioner. I've not practiced in the area of family law, so you have to bear with me. But am I correct that sometimes family law solicitors rely on local authorities to implement orders that are obtained? And if that's correct, did essentially the reduction of services in local authorities, did that affect the implementation of those orders?
I think so. It tends to be in I suppose what I would describe as public child law cases concerning applications for permanence and the like, where there will often be a requirement, if contact between the natural parents and the children is to continue, that contact will be supported in some way or supervised in some way by the social work department of the local authority. And I think logically it follows that if the capacity of the social work department is stretched, then that has an impact on the ability and the quality of the supervision that they're able to offer.
And was that your experience or the members' experience during the pandemic?
Beyond the case that I've referred to, I can't recall specific examples.
Okay. At paragraph 19 of your statement, you discuss issues about advising, so I think this tends to be advice, you're talking about advice work, advising parents about seeing children that they didn't have primary custody of. Was there particular issues with that in terms of geography?
I don't think in terms of geography, no. I think in terms of clarity about what a parent should do in those circumstances and what they could expect, it was difficult.
And when you say clarity of the Scottish Government guidance? Or maybe just guidance, guidance generally?
I suppose so, but I think there's a limit in what we could expect the guidance to provide for. I think if we were having our way, it would be ideal if the guidance told us exactly what a particular individual could do in particular circumstances, and that was never going to be a possibility. But as a result of that, I suppose in relation to disputes concerning the care of children, which can be very thorny anyway, the additional area of dispute arose in relation to, first of all, whether contact could take place safely at all, and if it could, what reasonably a parent was entitled to expect would be in place in order to satisfy them that it was appropriate for contact to take. Would it be necessary for a negative test to have been provided before contact could take place? Was it necessary for social distancing to be observed during the operation of contact? Where would contact take place in a way that would minimise the risk of infection? These were all issues which we had to form a view on and try to advise on as best we could very, very quickly and in accordance with the guidance and what we understood it to be.
And I think I can't take you to a particular paragraph, but I think you say within your statement that the Family Law Association wasn't issuing guidance to its members. Is that correct?
Yeah, that's correct.
So what guidance were the family lawyers practising in Scotland relying upon?
I think we would be relying firstly on the government guidance that was available, and then separately on what guidance we could take from decisions that were being made by sheriffs and judges in cases that were pending as things progressed.
And you mentioned in your, but in paragraphs 22, you say that the court session was issuing guidance as early as March 2020, and that the sheriff courts were issuing guidance. But you also say within your statement, I don't have the paragraph in front of me at the moment, that what was helpful was guidance that was being issued, I think, locally in local sheriff courts.
Well, that was because
It's paragraph,
the practice...
It's paragraph 28, sorry, I'll take it to you.
The practice varied from sheriffdom to sheriffdom. Now that was to do with the conduct of business, how business would be conducted. At the start, what business would be dealt with, what would be processed as urgent and what would be held in abeyance. And those took the form of either practice directions or guidance in the sheriff court issued by the sheriff principal, in the court of session, if memory serves, issued by the Lord President. And that was clear, that guidance in terms of the practicalities of how to submit documentation, what cases you could look to have progressed, how you would go about trying to reactivate a case that had been paused. And that was clear and was updated pretty regularly. I think the initial guidance that I've mentioned from the Court of Session, if memory serves, that was to govern the position for a matter of a few weeks up until about the middle of April 2020, at which point it was updated. And in the Sheriff Court, it varied, but directions and practice notes were issued on a regular basis. And in addition to that, certainly in Edinburgh Sheriff Court, the Family Court Users Group would issue circulars to practitioners following stakeholders' meetings with the court on a fairly regular basis.
Thank you. We've talked about the training that was carried out by the Family Law Association. I'm now going to move on to this paragraph 36. I think you deal with this and the following few paragraphs. Training of trainee solicitors during the pandemic. Now, would I be correct that prior to the pandemic, trainee solicitors were principally office-based? Would that?
Yes, that's correct.
And following the pandemic, they were principally working from home. Is that fair to say as well?
Yes, initially exclusively from home, unless they were furloughed. And then subsequently, I think the norm would be that there was a mixture of working from home and working in the office. Now it will vary from firm to firm depending on what their expectations and requirements are.
I mean, what are the particular issues or disadvantages of a trainee even carrying, I suppose, having some of their traineeship, if not all of it, undertaken when they're doing it wherever they live?
I think it depends on the individual. It depends on the team they're working in. I think it's very difficult to replicate the training that you receive by osmosis, working in an office environment with more experienced colleagues. Speaking from my own experience, I have learnt a huge amount during the course of my career, observing colleagues in meetings, hearing colleagues on the phone, having an opportunity to speak to a colleague across the office about something that you are struggling with or uncertain about during the course of the working day. In addition to hearing and seeing other practitioners in counsel and court, I think that aspect of training is very difficult to replicate within a working environment, and I consider that that's an aspect of training that's of considerable value and importance. I think the other aspect of it relates to the support that colleagues and supervisors are able to provide to not just trainees but more junior members of the profession generally. And I suppose it doesn't have to be junior members exclusively. There is a far greater ability, I think, to pick up on difficulties in cases or just general worries that a colleague has if you are seeing them regularly, speaking to them regularly in person in an office environment, than it is if you are seeing them even once a day via a morning update over Microsoft Teams or Zoom. Now, I recognise that can vary from person to person. There will be individuals who are far, far more willing to pick up the phone immediately as soon as something is bothering them, rather than ruminating on it. But I think it's a different thing needing to rely on that person doing that as opposed to being able to pick it up for yourself and check that things are okay. I think if you have an environment where people are working from home, or even if time is divided between home and the office, again, the value that you get from seeing the person physically in the office is difficult to replicate or substitute for.
I mean, a trainee, it may be their first, in most cases, it may be their first, I suppose, real proper job as a professional, a responsible job. Were you aware of any, I suppose, pressures on their mental health arising from carrying out their traineeship from their home?
I think certainly there could be. Yes, and there were instances that I was aware of where that was the case. I suppose what I don't know, and what it wouldn't be for me to comment on, is whether that was linked specifically to working from home. But I can see that it would be, and I think practicing in the field of family law, you can find yourself speaking with clients about subject matters that are upsetting or distressing. You can find yourself having discussions with individuals that are challenging for a range of reasons, because the advice that you're giving doesn't meet with their expectations, because they are extremely distressed about the situation that they find themselves in, or because they are seeking advice for something or about something which, for a range of reasons, you are able to provide assistance that is very, very limited.
Just to move on to the kind of final chapter of your evidence, you discuss remote hearings and lessons learnt in paragraphs 47 to 51 of your statement, and I suppose I can perhaps just, you say that the association generally is the view that the ability to hear family cases by the court remotely is a positive development. Are there particular cases which you say should be heard in person?
I think if a party wants a case to be held in person, given that these are matters which are often deeply personal to them, I think it is important that if they are not being afforded the opportunity to have that case heard in person, there is a good reason for it. There is a significant ability on the part of the courts now to accommodate hybrid hearings, where part of it is in person and part of it is over video link. And I think for cases which have an important subject matter to the participants in them, but where there are good practical reasons for some evidence to be dealt with remotely, for example, I think that is a good compromise. Generally speaking, I think there is a value to evidence being dealt with in person where possible. But I think practitioners generally in the field of family law would welcome the greater flexibility that we have to have evidence dealt with remotely now. You know, for example, it's far easier and more common now to have a professional give evidence remotely rather than having a company accountant drive up from England or along the road for the purposes of confirming the terms of an affidavit and perhaps being cross-examined on it for 20 minutes, 30 minutes. Similarly with expert witnesses, it's far more common for them to be accommodated remotely now. And witnesses abroad, again, are far easier to engage the participation of in evidential hearings than it was previously. I think for the reasons that I've discussed, often a child welfare hearing being in person can be preferable. It's pretty common for discussions to take place before a child welfare hearing about whether that issue can be resolved, and for the reasons which I've mentioned, the opportunity to have that is more limited if it's being conducted over a video conference. I think the ability to conduct procedural business remotely is a significant improvement in most cases.
Thank you. Mr. Foulis, we have your statement in its entirety, and I haven't, obviously, in the time available, been able to go through all of it. I'm just wondering, before I thank you for your time today, if there's anything in particular that I've either missed that you wish to highlight, or if there's something you realised after completing the statement, well, perhaps I should have mentioned that. If there's anything further you wish to add today.
No, I think the only observation that I would add is that my own experience, and I think the experience of colleagues, is that from what was a standing start, a lot was achieved in a short space of time when it comes to the ability of sheriff courts and the Court of Session to conduct civil business. When I was looking back in preparation of this statement, because the timescales were a little fuzzy, it did put into focus how quickly, albeit at different rates, business was able to resume. I think there's a question about whether we should have been starting at a standing start, but I think it's appropriate for me to recognise that for those involved within the court service, a lot was achieved within a short space of time.
Well, it just takes me to thank you both for your attendance here today and for the assistance in the preparation of such a detailed statement. My Lord, I have no further questions.
Thank you very much indeed. You might be interested to know, Ms. Foulis, that what you've just said, that things went very quickly, echoes what was said in evidence yesterday by a number of witnesses. So you're not alone in thinking that, and I actually happen to agree with you. The other thing is, since we've stopped giving evidence, I'll give you an anecdote. You're perfectly correct. In the family court and the Court of Session, we did do it quicker than anybody else. And the reason for that was that we'd been doing international child abduction cases by video link for 5-6 years, and therefore we were able to do it. And in fact, we were used effectively as the pilot. And you're right, we were doing proofs within 6 weeks. So there was a reason for it.
Well, that's helpful to know. Interesting to know.
Right. Quarter to 2, quarter to 3, I beg your pardon. I think we're coming back to the next.
Thank you, Lord.
Thank you. And thank you, Mr. Foulis. afternoon, Ms. Barami.
Good afternoon, my lord. Our last witness today is Ms. Julia McPartlin, who's the...
Sorry, good afternoon, Ms. McPartlin.
Thank you, my lord. Ms. McPartlin is past president of the Scottish Solicitors Bar Association. I want to start off by confirming your details. So your name is Ms. Julia McPartlin.
Yes, that's right.
And you are a principal solicitor at Hughes Walker Solicitors and past president of the Scottish Solicitors Bar Association.
That's right.
Thank you. Now, you've provided with the inquiry with a Rule 8 response, is that correct?
Yes.
Please would you start off by briefly telling us about your own background and a little bit about the Scottish Solicitors Bar Association, please?
So I'm a criminal defence solicitor based in Edinburgh. I've been doing that for about, I think, 16 or 17 years. The Scottish Solicitors Bar Association is a national bar association across Scotland. It was formed in April of 2021, and we have individual members, but we also act as I suppose, an umbrella organisation for local bar associations to try and coordinate our efforts, so to speak. And I've given some of the details in the Rule 8 response about what the aims are. A lot of what we do focuses around legal aid and access to justice, but other issues that affect, at the moment, it's just criminal defence solicitors that we represent.
What prompted the formation in April 2021?
It came against a backdrop of, we'd had sort of greater communication between bar associations, particularly the bigger bar associations, so Glasgow, Edinburgh, Aberdeen. Again, a lot of that was to do with legal aid and conditions for defence solicitors. And I don't think it's the first time that there have been attempts to form a national bar association, but I suppose things came together quite well because we'd had some joint action around about that time. There were a lot of issues that we were all facing in common, so the timing, I suppose, was right, and that's what happened.
Thank you. For those unfamiliar with criminal defence work, could you tell us a bit about the profession, including the settings in which you work?
Yes, so, well, for the typical day for a criminal defence solicitor, we'd be attending at court. From my point of view, that's usually the Sheriff Court or the Justice of the Peace Court, but also instructing counsel in the High Court as well. So for a defence solicitor, you would spend certainly the morning, probably the afternoon as well, at court representing clients. So there is a lot of face-to-face, close contact with your clients when you're taking their instructions. Mm-hmm. You're then also working in the court environment where there are lots of other people with their clients. Day to day, we have intermediate doubts procedural hearings, but also trials, and trials would involve witnesses coming to court. And I suppose from a COVID perspective, it doesn't particularly lend itself very well to social distancing because there are a lot of people about within the court building, also all the staff, the clerks, etc. So.
And do you also make visits to police stations and prisons?
Yes. And I suppose as well, we from time to time we'll have consultations at our offices with clients and with counsel.
Yeah, thank you. Now, while the SSBA wasn't formed until April 2021, would you be able to tell us in your capacity as a criminal defence solicitor of any initial concerns you had about practice in February and March 2020?
Yes, so at that time I was president of the Edinburgh Bar Association, so I was quite involved from that point of view. I think the feeling was that the changes to court business that COVID prompted were, I suppose, something of a surprise. There wasn't really anything in the way of forward planning. So I know you'd asked about February before lockdown. I don't recall there really being a lot of talk at all about the pandemic spreading and what that might mean for us. And when it did happen, I mean, it was quite chaotic, to put it mildly. There was certainly the first few weeks and days, a lot of people didn't really know what was happening, how we were going to deal with things, and there was quite a lot of confusion about whether we should be actually attending at court or not. So, and in fairness to the other people involved, this obviously was completely unknown territory for the court system as well.
Thank you. Now, you say in your relate response that criminal defence solicitors were not designated key workers. What was your opinion on that, and how did that affect practice?
Well, I mean, speaking with colleagues, one of the sort of difficulties was things like accessing childcare. Just by way of an example, a colleague I'd spoken to, whose wife was a nurse, was told that although she had key worker status, he didn't. I mean, ultimately, they were able to get their child into a nursery placement, but if we'd had the key worker status, that would have been a lot easier. Yeah. And so obviously quite a lot of people that have young children. So that's probably the primary disadvantage.
Did SSBA members find travelling between local authority or different health board areas problematic in the absence of key worker status?
I'd asked my colleagues about that, and I'm not aware of anybody having particular difficulties. What was happening a lot was that people would cover cases for each other. So a solicitor in Edinburgh who has business in Glasgow would ask a local agent to cover it. So that was quite common, and people helped each other out in that way. But I'm not aware of anybody having difficulty when things started moving a bit more freely.
Okay, thank you. How did the pandemic restrictions impact police interviews and consultations with clients?
So there were various kind of attempts to try and solve this problem without whilst maintaining social distancing. So, for example, there was a period where they sort of tried having telephone interviews. This is prior to court appearances. That didn't last particularly long. There were difficulties about the sort of quality of the telephone lines. I know that sounds, in this day and age, that sounds a bit ridiculous, but a lot of the court buildings are old and are not great for reception, that kind of thing. But it's also quite difficult if you're speaking to a client for the first time. It's different with clients that you know quite well, but for new clients, it's quite challenging to get a feel for what their vulnerabilities are, how much their understanding of what you're telling them, particularly if it's all new. So that didn't last particularly long. The video consultations, I think, were a little bit more successful because you at least then you can see the face, you can see, you get a better idea of what they're taking in, what they're not. So that was the sort of changes that happened. With police stations, actually were not too bad in the sense that they already had rooms with, you have the client on one side, glass in the middle, and the person on the other side. So that, in a way, is already there. So that wasn't that didn't really require too much change.
Did you find there to be sufficient communication from Police Scotland about changes that were being put in place?
Well, I mean, because the changes weren't particularly significant, no, but that there didn't really need to be, if that makes sense. And we had, there was a, I can't remember what they termed it, but they used Falkirk Police Station as a sort of COVID hub, so that if there were people in custody who had or were suspected of having COVID, then they used that. And the protocol for that was that we would do a video link consultation. I think, generally speaking, they were avoiding doing interviews in that kind of scenario.
And then moving on from police stations, how did the pandemic affect hearings and trials, and did all hearings and trials eventually move online?
There's different things across the country. I'm probably not the best place to speak about virtual trials. I know that was trialled, I think, in Aberdeen. I may be wrong about that, but I was based in Edinburgh where that didn't happen. So the vast majority of business trials were administratively adjourned. So the Sheriff Clerk's office would fix new dates for that. So that obviously created a backlog. I should say I'm talking about the Sheriff Court because it was different with High Court cases and solemn cases where they had the cinema juries. And on the whole, that actually seemed to work quite well, as close as you could get to having a regular pre-trial, pre-COVID trial, sorry. So that was, I think, fairly successful, but for the less serious business in the Sheriff Court and the JP Court, most things were going off. So yeah, that obviously was problematic.
What impact did that have on your clients?
Well, obviously, I think most clients obviously understood the reasons why this was happening. So from that point of view, you know, it wasn't difficult to explain what was going on. But then it's quite anxious for some people to have these cases hanging over them, particularly if there are bail conditions. So, for example, in domestic cases, you might be told that you can't approach or contact your partner for a period of time, and that's the thing that will, I suppose, cause people the most stress and the most difficulty. Also, as well, with COVID, the time limits for keeping people in custody were extended, and are still extended now. So that's very difficult, I think, and particularly for clients that are appearing in the High Court. It's not unusual for them to be remanded for kind of up to 2 years. And I know these are serious offences, but again, it's not what you would wish for in a justice system.
And did you find there to be sufficient communication from the court service about cases being postponed, about procedures being put in place?
I mean, the short answer is probably no, I think. We were, particularly towards the beginning, there was huge confusion about what was happening. I mean, for example, when it came to bail undertaking cases, so where a person is released from police custody on the condition that they come back to court on a fixed date, and it's a condition of their release that they have to do that and they have to appear. We, certainly in Edinburgh, we were asking, well, what do we do? Because on the one hand, the security staff at the doors of the court were refusing to let people in. On the other hand, they have an undertaking from police that they should be there. And I mean, in that particular situation, in Edinburgh, we effectively made the decision ourselves and said, look, we're going to tell clients not to come. And that way, at least we've got some sort of certainty. But that was a decision I think that should really have been taken by the court or by the Procurator Fiscal Service. So, I mean, as it happened, it was fine if we had instructions for them. There wasn't really a reason for them to be there unless it was a plea of guilty. But yeah, that's an example of the kind of confusing nature of what was happening.
Was there any guidance issued by the Scottish Government in respect of court and police matters? And if there was, did you find that helpful?
I have to say, I mean, my memory's not great for a lot of these things, so I can't remember really what specific guidance thing there was. We were mostly communicating. There were definitely differences across different courts. So we were mostly communicating through Scottish Court Service, through your local Sheriff Clerk's office.
So there was no national guidance to try to ensure consistency across jurisdictions?
I mean, if there is, I don't recall. So, yeah. I mean, other than that, obviously we had the general guidance about distancing and that kind of thing.
Thank you. Were the differences in practice that you mentioned between jurisdictions, were they significant, or did they relate?
The impression I get from speaking to colleagues, I think some of the smaller courts were easier to manage. I suppose for obvious reasons. I know. Obviously, I put this in my response as well about the situation in Edinburgh, where we, the Edinburgh Bar Association, had ended up having to take responsibility for distributing new court dates, so the administratively adjourned court dates, and I know that wasn't happening in other jurisdictions. And I don't think we ever really got to the bottom of why the clerks in Edinburgh weren't able to do that, because in effect the Edinburgh Bar Association, which is a voluntary association, were doing part of their admin and letting our members know what the refixed court dates were. And if you weren't a member of the Edinburgh Bar Association, then I don't know how you would get that information.
Yeah. Did you offer to provide Edinburgh Sheriff Court with your mailing list so that?
Yeah, we did. Yeah, and we had that, and we would have the consent of our members to do that.
But that wasn't seen as a solution to the issue.
No.
What do you think would have been the impact if the Edinburgh Bar Association hadn't stepped in there? Would cases have been able to call?
What we were doing is, where cases were being administratively adjourned, they were then sending us the new dates. So effectively, people wouldn't know what the new dates are. Or I suppose what you would actually have is the clerks being inundated with individual solicitors asking for the new dates. Is what would have happened, I think.
Once hearings started resuming, can you tell us about protective measures that were put in place by the courts to limit the spread of COVID?
So there were quite a lot of variation, I think, across different courts with this. I mean, some of them are better set up for it. I mean, they had lots of, signage and everything about distancing. It was quite haphazard. I mean, there were talk about having screens between the dock and the rest of the court. I think that happened in some courts. It didn't happen in Edinburgh. That was sort of confusing. One of the things that we'd asked for a lot was somewhere where we could consult with the clients before court in a socially distanced manner. That never really happened. I mean, I think at one point there was a suggestion we should do it outside of the court building, but we obviously can't really talk about confidential and often quite sensitive things outside. I mean, yeah, I'm trying to think what else. I mean, within the cell complex, I mean, that already has like perspex between you and the client. I mean, that was sort of fully sealed over in some cells. But I can't say that there were. It's difficult to sort of pinpoint the huge changes that took place. That's that. Sorry, I know it's probably not a great answer, but yeah, I mean, obviously people were wearing masks and things, but the same as you would have anywhere during COVID.
If during a trial a client wanted to give further instructions, or during a hearing, would the court adjourn in that situation, or where was technology used, or was anyone allowed to approach?
So these were the sort of problems that were discussed, and in fact, we did have, in the context of video links, there was a sort of a genuine question of, well, what do we do if there is, just sometimes there's one extra thing they want to tell you. I think in practice, although we were told that we would be allowed to adjourn and do that, I think in practice it probably didn't happen terribly often. But yet that was something that was discussed.
Okay, thank you. Now, can you tell us about the operational measures that criminal defence firms and practitioners had to take to adapt during the pandemic and the costs of those measures?
Well, I mean, the sort of things that we were using more, like video links and things. I mean, we already had, prior to COVID, there was the ability to do, for example, prison video links. Mm-hmm. So I don't think there's any cost there. We would already have the equipment for that. And most criminal defence firms are quite small, so in a way social distancing wasn't such an issue because we're not talking about having lots of people in an office. There were, obviously towards the beginning, a lot of firms took advantage of the furlough scheme, so you had less people in, and I know people were much more flexible about working from home and things. So I do think that's probably one area where there wasn't a huge, certainly not financial cost in terms of providing equipment or PPE. But yeah, as I say, part of that is because a lot of staff would have been on furlough and not in the office.
Mm-hmm. Thank you. And would I be correct in saying that most criminal defence work is funded by legal aid?
Yes. We do have private clients, but that's definitely the minority.
Mm-hmm. And you mentioned in your relate response that the volume of cases being processed by the court was greatly reduced, and you've alluded to that now here. Presumably that had an effect on fee income coming into firms. Mm-hmm. And you also state that solicitor firm cash flow was impacted by cases overall taking longer to come to conclusion. What was the overall impact of this on the financial resilience of firms?
But so obviously cash flow was affected. We were the Legal Aid Board brought in provisions to allow us to submit interim fees, but you then have the work later that you still got to do. So that helped to some extent. But I think furlough was probably, I think furlough saved a lot of people's jobs. It was very, very important to allow people to keep their staff on.
Would you say that criminal defence firms went into the pandemic on a financially strong footing?
No, I mean there's a whole history of campaigning for better legal aid rates, particularly. Our position as defence agents compared to other people in the criminal justice system, particularly procurator fiscals, we're at a real disadvantage in what we can afford to pay our solicitors, not just in wages but in terms of benefits. So we weren't in a hugely strong position to begin with, and yet the pandemic obviously did not help that.
You mention in your response the Scottish Government's Resilience Fund, and you state that initially less than a third of firms that applied were accepted, but following SSBA negotiations with the Scottish Government, a new scheme was introduced which saw 332 out of 364 applicant firms being granted awards. Mm-hmm. What was the issue with the first scheme, and what was changed to make the second scheme more successful? And to your knowledge, were any criminal defence organisations or representatives consulted by the government prior to the introduction of the first scheme?
So I think, I'm not sure, but I think the Law Society would have been, I would imagine that they would have been consulted before the first scheme. I don't recall the precise mechanisms of each of the schemes, but the model that the Legal Aid Board had chosen, obviously, in the first place, didn't lead to the money being distributed even. Mm. Then the revised model, I think from memory, it was based on sort of previous years' legal aid grants, so sort of roughly what you would have been what you'd have been expected to earn in a normal non-pandemic year, and obviously that it led to more firms getting that funding, which is what you would have expected in the first place, because as you've identified already, most criminal defence firms are doing a majority of legal aid work. So,
do you think more extensive consultation before setting up the Resilience Fund would have avoided issues coming about?
Yes, and I think it's something we need to check with the Law Society, but I think the model that was used for the second attempt at distributing the money, I think that had been floated before, so I think it would have helped.
Thank you. Did you find the timing of the Resilience Fund being introduced to be helpful, or was it late on?
Well, the first set of applications I think were in, it was March so it was like a full year after lockdown. And then there was quite considerable delay. Part of the delay, before we got to the second Resilience Fund, it was to do with how the civil servants service are able to sort of, label this as a particular fund. So they did change the name of it. There was quite a lot of red tape and hoops that we were sort of trying to jump through to redistribute this money, which should have been there in the first place. So that then led to further delays, which I think everybody found quite frustrating, as you can imagine.
Can you tell us about the impact of the pandemic on recruitment of trainees?
That just stopped, really. Nobody was in a position, particularly with trainees, because if you take on a trainee, then you're committed to a 2-year contract, and I think at that point firms didn't really have the confidence. And as I said before, quite a lot of firms had people on furlough already, so you wouldn't really be in a position to take on new people.
Has the pandemic had an effect on the number of practising criminal defence solicitors?
I don't know if I can. The thing with furlough, the really good thing about it was that I think surprisingly few people lost their jobs, so people were able to come back. Does it have an impact? I don't know. I suppose if you're a young law graduate and you're looking, where you want to go ahead in your profession, criminal defence is perhaps not the most secure. So I don't know. I think that's probably beyond my ability to answer. But
that's fine, thank you. And lastly, do you have any concerns regarding the future of the criminal defence firms following the pandemic and the issues you've spoken about?
Well, these are sort of general concerns that obviously legal aid funding is still an issue for us. So, this is out with the remit of this particular inquiry. But, so yes, there are still lots of concerns. Touch wood, this doesn't happen again, but we're a sort of vulnerable profession. When things like this happen, it's very difficult if you're just making ends meet. So.
Sorry, one more question. Sure. With the closure of courts and the move to remote hearings, do you know if the court duty solicitor services were impacted?
Well, no, they were still. The duty scheme was still going. There were a lot less people being kept in custody, though, I have to say. I think there was quite a move for. If you didn't have to keep people in, then the police wouldn't. So the number of custodies coming up was significantly down.
Thank you. Is there anything we haven't covered today that you wish to highlight at this point?
No, thank you.
Thank you.
Very good. Thank you. You're perfectly correct. I'm sorry. The issue of legal aid is not within my terms of reference. You will, however, perhaps not be surprised to know that this week when we've been dealing with justice, you're not the first person to have raised the issue of the inadequacy or the difficulties caused by low levels of remuneration caused by legal aid. So you have my sympathy, but
Thank you.
not much else. Very good. That will do for this week. 10 o'clock on Monday morning.
Thank you.
Thank you.